Welcome to another episode of the Top Attorneys of North America podcast. Today's episode is geared to anyone in California who has been in an accident or has been hurt on the job, or even anyone interested in having an inside look into the civil landscape within the California court system. When you're hurt and your life is on hold, you ask two questions about an attorney. The first one is obvious. Will this person fight to get me every dollar I deserve? But the second one is subconscious, something you feel in your gut. Does this person have the strategy, the mindset of a winner? Today, we are talking to a winner, a no nonsense and very candid Encino, California based personal injury and workers' compensation attorney, David Lupoff. He's here to break down how he maximizes settlements and outmaneuvers the delays in a system that often feels designed to work against you. David, welcome to the show.
Thank you very much, and I'm glad to be here today.
Excellent. I'm glad that you're on as well. And just a quick intro about yourself. How long have you been practicing personal injury and workers' comp cases?
Approximately 23 years.
Excellent. Let's jump right in and start with the bottom line. Every client wants the best possible settlement. When you talk about maximizing a case, what does that actually look like in your practice? What are the key pieces you're putting together?
Maximizing a case is done through evidence. You have to be able to gather all the evidence that's favorable. And with an attorney like me, what I basically do is focus on your case. There's a lot of law firms who advertise heavily and they just get hundreds of clients a month. I'm not one of those. I really put a lot more time into each case. I have a smaller firm. I don't want that many clients. I like a smaller caseload, so I have the time to maximize my client's case. And the way to maximize my client's case more specifically is you look at the type of injury, the nature and extent of the injury. You look at the liability, you look at the pockets, meaning the insurance company. There's a lot of little factors you have to look at. There's special damages. Sometimes there's loss of consortium or negligent infliction of emotional distress. So you have to gather all the causes of actions. You got to put the pressure on the defendant, and you go from there. It
Yes,
really
sir.
helps you maximize your case.
Yes, and you alluded to those billboard attorneys. So when someone signs a case up with you, they're getting you, not just an intern.
Right. Yeah, we have no interns. It's just me and my staff. No
Excellent.
interns.
Excellent. And beyond just medical bills, how do you put a number on the full impact an injury has on someone's life, whether it be from lost wages to future care?
You see these commercials on Instagram, just push a button here and you'll get your case value. Mm-mm. It doesn't work like that. There's a lot of variables involved in calculating the number. First of all, if you lose a leg, there is no number that's going to grow your leg back. So that's just the reality of it. But when you're looking at trying to arrive at a number, you look at how badly did the client injure himself or was he injured? What about the special damages? Did the injury knock him out of work? That's a very important question. If he's a CEO for Disney and he earns $500,000 a year, now he can't work anymore. Well, what do you think his case is going to be worth? If he's an attorney or a doctor, you've got the same thing. If he's a plumber, you hire an expert. What they do is a lifetime economic analysis to see the case value. So it's not just the injury like you would see on Instagram. You have to look at the specials. There's a lot of variables. Then does he have kids? Is he active? Then you've got the general damages, the pain and suffering. Um, there's a lot of factors involved in putting a number on a case, but again, no matter what the number is, it's not going to make a leg grow back. It's not going to rise you out of the wheelchair. So we have to get a number that's going to compensate you for all your injuries.
Interesting. And you're absolutely right. I see a ton of these advertisements all over social media. So I think it's very important that listeners know that. And many people think negotiation is just about arguing, but I know that there's leverage moments. What are those leverage moments and how do you use them to strengthen a client's position?
Well, I want to jump back a little to the word arguing. Um, Arguing implies that you're actually having a fight with them. That's not the case in the world of law. Arguing means you're arguing your points. For instance, and this transitions into discussing leverage. When you argue, you're really just raising all the points. You're bringing in all the evidence involved in your client's case. You leverage your case by using all the evidence that you gathered, which includes police reports, incident reports, witness statements, expert reports. It goes on and on. There's a lot of moving parts to a civil case. And I'm the kind of attorney that actually works on the case to gather all this information. I'm not one of these larger firms that get 1,000 calls a day and I just want to move the cases along. So I'm not really looking at each case as much as a smaller lawyer like me would do. I get really into my clients' cases. Very important because there's a lot of details that a move them along lawyer would miss. And it's the details is when you maximize your client's case.
Perfect. And what's the biggest piece of advice as a personal injury attorney that you may give to your clients or to your friends, to your family?
Well, there's really two pieces of advice. Two pieces of advice. The first piece is call your insurance broker, make sure that you have uninsured motorist and underinsured motorist, the maximum amount. How do you get the maximum amount? You have to try to get a higher policy limit. For instance, if you have a 30/60 for your policy limit, you cannot get uninsured motorists higher than 30/60. If you get 500,000, then you could get uninsured motorists for 500,000. Well, why is this important, Dave? Well, because many people, I don't know the percentage, maybe 40 to 50%, especially in California, are uninsured or underinsured. And when they hit you and you have no uninsured motorists, there's nowhere to go. Nowhere to go. You are screwed. So you want to make sure that you update your insurance policy, look at your policy limits, make sure everything's in place. The next piece of advice, it's really simple. I don't know why, but people have a tendency to apologize for everything. You walk past somebody in a store and they're down the aisle and you go, "Oh, I'm sorry. Oh, I'm sorry. Sorry." Well, when you have a car accident, don't apologize unless it's like really your fault. But don't just apologize just because they're used to apologizing, because that could easily be written in the police report and make your case just a little uphill. So don't apologize to an at-fault defendant. All right.
The, if the defendant was underinsured or was uninsured and your client had little to none uninsured motorist insurance or underinsured motorist insurance, are they just out of luck or is there any other recourse for them?
Well, that all depends on if they hit Jay Leno or janitor. All right.
How much of a difference does it make when an attorney prepares every case like it's going to trial versus just hoping to settle. What message does that send to the insurance company? Do you have a reputation then in the courts? Do they know that, oh no, David's going to take me to trial if I don't give him a good offer, or let me just throw this at David because I know he wants to settle?
All right. Well, that's a difference between pissing in a toilet and pissing in the wind. So, excuse me, everybody. Calm down, everybody. Anyways, the moment they walk in the door, you have to start preparing for trial. So the defense knows that when they see your letterhead coming in, that you're going to take him to trial. You're not dicking around. Makes a big difference.
Let's talk about a topic that I know you have strong views on, the system itself. You're very candid, and you're candid that the workers' compensation system in California has some serious flaws. Where are the biggest blind sides for people who have been injured on the job?
Yeah. That's there's a lot of unpacking to do here. The comp system is not designed for the injured worker. It used to be, but when the money starts rolling in from the large corporations and insurance companies, the law just sort of switched and made it more difficult to litigate a work comp case. They become very complex. So the biggest blind spots are, I think, well, let's talk about the blind spot and how to avoid the blind spot. How's that? Let's go in that direction. So
Okay.
the first blind spot is your case being denied right out of the box. How is your case denied? Well, your case is generally denied because you don't report the injury to your employer. A lot of employers will fire you after you report the injury in order to avoid a comp case, but that's a whole different discussion that I don't want to drift into. However, when you report your injury, don't report your injury to the guy working next to you on the factory line. He's not going to help you. You have to report the injury to your employer, to the supervisor, as soon as possible. Sometimes they may not be till the next day because they're working the weekend. So you got to make sure you report it. And when you report it, say the body parts. Say it. You could injure your shoulder, your neck, your back, and your leg, but your back might hurt you the worst. So you're just gonna say, hey man, I hurt my back. Yeah, well, that's not going to help you. Say each body part you injured, and definitely when they send you to the doctor, you have to say those body parts. And that's how you avoid getting your case denied. A lot of times they'll deny your case just because it feels good and they just want to drag it along. But that's just a system. The next blind side is when they deny your body parts. They'll deny your leg, but they'll accept your neck, whatever. They'll deny those body parts. So I, as your attorney, would have to file for a QME panel. That's going to a doctor to decide whether or not that body part was work related. Or we go to a priority conference if it's a factual denial, meaning, well, he never reported it, or he didn't report it for 2 weeks, or we didn't even know about the injury. So those are the two ways to overcome denials, anyways. Other than that, there's other denials that are blind spots as well. Those are the worst. Your doctor will do what they call a request for authorization to the insurance company. Mr. Jones requires an MRI to his neck, and then they'll deny it. Deny an MRI? What does an MRI cost? I don't know, $500, let's say. Well, the UR denial, it's called a utilization review. That's why I call it UR. The UR denial will cost 150. Then you send it to independent medical review. Maybe that costs the insurance carrier another 100. And if that MRI denial is upheld, well, what do? You have to wait a year until they request it again. What does that mean? That the insurance carrier actually spent several thousand more dollars keeping your case open an extra year only because they decided to deny your MRI. For me, it's mashugana to deny diagnostic testing. Just you got to be out of your mind, but they do because diagnostic testing is really the only thing that could move your case forward. If you never get a diagnostic test, an EMG, an MRI, or whatever it is you need, you can't move your case forward. There's no QME doctor or agreed medical examiner doctor that's going to release you from care without looking at some kind of diagnostic testing. They cannot give a proper amount of permanent disability at the end of your case. So I think the diagnostic testing is the most important phase of your case, and for some reason it's denied. I have a couple ways to go around it, so you'll have to come into my office to discuss it further.
So many details. Sounds like if you mess up one time, you're back at square one. And I have to tell you, Dave, it's synonymous across the country because the delay that they put on the clients, the delay in cases. Because I spoke to a personal injury workers' comp attorney here in my neck of the woods in New York, and I did ask him, "What's the one thing that you would change with the system?" And he told me the same exact thing, that the one thing he would change is that he wishes that the court would treat these cases like criminal cases, where they push them along, they move them along. You don't have those awkward stalls. And if I can ask, because I know we mentioned two very distinct areas of law, workers' comp and personal injury. Uh, as an attorney, how does your role differ with each case? How are the cases different?
Well, in workers' comp, the reason why there's so many delays and so many problems with the medical reports and whatnot is because the defendant controls they control the evidence,
Hmm.
right? So they pay the doctors, they pay the qualified medical examiners, they pay the primary treating physicians, they pay for everything. So because of that, a lot of QME doctors are a little nervous about always giving everything to the applicant in the medical reports. They just get a little nervous about that. So many times you'll find neutral medical reports like a QME leaning more towards the defendant. Otherwise, in personal injury, we control the evidence. We hire the doctors. We get the testing done. We hire our own experts. We do everything. So that's the main difference. So we get better reporting. But in personal injury, you have to use the right doctors. There's a lot of doctors that are actually on the insurance company's shit list. So when you see Dr. Jones come in, they're all laughing on, come on, this doctor's got no credibility. Let's see, he always writes the same crap in a template. This looks just like the last report. But if you hire the right doctors, the credible doctors, it adds more credence to your case and you get better outcomes. But a lot of the move them along lawyers will use whoever is around. Now, I say this, there's a little caveat here. When you live in the sticks, I don't know where the sticks are, Tulare, just certain parts of California, is it Tulane? I don't even know anymore. But you live in certain areas in California where there's just not a lot of doctors. I got to give the client a choice. You could stay with the local doctors. I don't even know those guys sometimes. Uh, or you could travel to one of the doctors that I find in your proximity. Um, but certainly the doctors really make or break your case.
Interesting. I didn't realize that in workers' comp that there's so much, like the deck is stacked against you almost.
Oh yeah,
When,
well, I'm sorry, did I transition into comp? That was actually personal injury for a moment that I was talking about.
mhm.
But since you mentioned workers' comp, it's still the same thing in work comp. in work comp, you have this company called Concentra, and they're just an employer doctor. They're kind of everywhere. They're even in the sticks, but they're very defense oriented. You could walk in there with your hand cut off and they'll send you back to work. So, you know, it's just, the system's a little nutty sometimes, but the same principle. If you live in the sticks, you still have less choices of good doctors. You know, Kaiser's not really a good facility for employees. Concentra really isn't. And I hope nobody sues me here. I'm just saying, but usually those are the employer doctors. There's other known facilities. So being closer to the city really helps out, I think. It helps us find the better doctors, whether in comp or personal injury.
Perfect. Let's shift to the client's perspective. Obviously, anyone that comes to see you, injured, stressful situation, possibly not earning, they look to you for confidence. How do you demonstrate that winner energy without just being a loud bulldozer?
I actually do my job. I don't throw the
Yes.
file aside and watch it grow dust. I get in there and I have a positive attitude anyways. I'm a little cocky. I got to admit. I think a lot of those in the defense bar know me. I do have a reputation out there, and I don't know if it's good or bad, but I know it's a reputation, and I just always hope I live up to that reputation, no matter what it is. Whenever they see my letterhead, at least in the comp world, they always assign a partner to my case. So that's what you're getting.
Obviously you're a no nonsense guy. Do you have a detailed plan or approach when laying it out to a client, or are you just, here's where we are, here's what's next, and here's what a win looks like?
Depends on the case and it depends on the client. Some clients just want to know what I'm going to do next, and others want to know the long-term strategy. Personal injury is really just more of a template. You know what to do. There's an order of things. Comp comp is kind of like a template, but sometimes you have to just jump off the main highway and take a lot of side roads. And it's very hard to explain this to some of the clients. It depends on the client, how they're able to comprehend it. Um, the Spanish speaking clients is a little harder sometimes with an interpreter because of the complexities of work comp. There are more side roads, I think, in work comp to take if you're a smart lawyer. But I like to give, well, I like to give the strategy overall. But the problem with doing that is, at least in comp, there's always that bump in the road or something will change suddenly and you have to do something different. To me to say this, but there's really a lot of stupid defense attorneys. I have to jump on side roads. They just do weird things that don't make any sense. They try to benefit their client. They want to show their client what a great lawyer they are. They just want to defeat that Dave Lupoff dragon, you know. They want to take me down, and I just love it. And I crush him. I don't like really speaking like this, but it's it's just the way it is. Again, um, circling back to what you asked, it really depends on the client. Some clients just want to know what you're going to do next, and then that's the end of the phone conversation. But other clients want to stay on the phone and want me to go through their case with them. Then they call back an hour later and ask the same questions. And then they call back the next day and ask the same questions. It depends.
If I could take something out of your answer, you said that you do like to crush the
Yeah, I
opponent,
like to
or
crush them.
excellent. And I'm
But
sure
but
that
I do it. I crush them with facts. I crush them with evidence.
Yeah,
Anyways,
it lends to your competitiveness. Then
right,
absolutely nothing wrong with that. And
correct.
let's stay on the topic of personal injury. A big thing I hear from injury attorneys, no matter what state they're in, is that clients should not speak to insurance adjusters because the adjusters are trained to get information to minimize your claim. Now, as an attorney, how do you stay calm and measured if an insurance adjuster is being difficult or they're taking you, off the beaten path, like you said? And why is that more effective than getting into a shouting match with them?
Well, getting into a shouting match with anybody puts you in a position where they're not going to answer the phone when you call. You always want to be in a position where they want to pick up the phone when you call, even if they're obnoxious, even if they're morons, whatever they are. So you don't want to act like some crazy asshole who just climbed out from under a rock to try to approach these adjusters and defense attorneys, no matter how dumb they are. You don't want to do that. You win them over. If I'm dealing with a jerk, what I do is I become a little personal with them and just talk about other things. I like cars. I love cars. I got a boat. I've got all kinds of cars. I've got things. I'm married. I got a dog, really beautiful dog. I got a couple kids. Why is all this important? Because they have this stuff too. So I try to connect with them on a different level to disarm them. It's very important because once you disarm them, you get further with them. You're not going to get anywhere shouting. If you're shouting at them, when they see your number pop up, they're going to associate your number with an asshole, and they don't want to deal with that. So that's how I deal with it.
Yes, sir. And your tagline, practicing law is a strategy like a game of chess, certainly makes a lot more sense to me now.
Well, when you play chess, I don't think anyone ever won a chess game by screaming at the opponent. You got to look at the board for God's sakes, where, look at the pawns, look at the king, the queen. And you got to move them accordingly. You don't just start yelling at your opponent. So yeah, it is like a game of chess. Exactly.
To the point, there's been a lot of pearls of wisdom that you have shared, truly valuable information for our listeners, especially for those injured in California. For our listeners in Encino, across the Los Angeles area, or who are feeling stuck, delayed, or undervalued by the insurance company, what is the best way for them to get in touch with you for a strategy call? Your website, email, phone number?
They could call my office, 818-385-0520. They could go to lupofflaw.com. That's LUP as in Peter, OFF as in Frank, law, LAW.com. They could contact me through that website. They could send me a text message at 818-943-0462.
Perfect. David, I always love our interactions and the dialogue. Thank you again for your time and for clarifying how to navigate in such a flawed system. It was really a pleasure having you on today.
Yeah, thank you very much, Sal, and thank you for having me. I appreciate you taking your time to put me on the air.
Thank you for listening to the Top Attorneys Podcast. The Top Attorneys celebrates the achievements of leading attorneys across the nation. To be featured, send a message or visit www.topattorneys.us.